Ignition sequence start. 6, 5, 4, 3, 2, 1, 0. All engine running. Liftoff. We have a liftoff.
Space technology companies invest considerable time and resources creating new systems. Those new systems often include valuable inventions that solve new problems faced by devices that are launching and operating in space. But how important is patent protection for those innovative technologies? My guest on this edition of the Ex Terra Podcast is Steve Sponseller, an intellectual property attorney and innovation strategist, and the author of Cracking the Patent Code. For more than 20 years, Steve has helped technology companies of all sizes create patent portfolios. Steve, welcome to the program.
Thanks, Tom. Great to be here.
Let's start with the basics. What's considered intellectual property?
There are a lot of different definitions, but my favorite when people ask me is it's creations of the mind. So they're intangible. So if you think about, I'll go lawyer here for just 10 seconds. You've got real property, your house, real estate, things like that, that's tangible. You've got personal property. Typically that's stuff that moves around, your car and your possessions. And then you've got intellectual property, which is things that you think of, whether it's creative works, it's a brand or a logo that you've come up with for your company, or it's invention, something that you've created. And it gets kind of special treatment because you can't necessarily touch it or feel it, the idea itself. But that's kind of what we generally refer to as intellectual property.
So the pace of innovation is really growing exponentially. Can patent and intellectual property protection keep up, and is it still necessary?
Of course, I'm biased, but absolutely. Patent laws and patent office rules and things like that have been keeping up since sometime in the 1830s, almost 200 years, when the patent office in the United States was formed. And think how much has changed. That was before airplanes, before all kinds of different things.
Sure.
So it continues the courts. I mean, they struggle with different things as technology evolves. Right now, they're really struggling with artificial intelligence issues. And what if artificial intelligence invents something? So there's issues there. So they're on top of it. They stay on top of it. The patent office updates their guidelines. So I'm confident that they can keep up. We're hoping that the patent office will speed up the processing of patent applications a little bit with some of this new technology. But they have been keeping up, and I'm confident that they'll continue. Is it necessary? In many cases, yeah, it is, because it's the way space tech companies in particular, they invest a lot of money to get prototypes, to do an initial launch or an initial placement of an item in orbit or on the lunar surface. You want to protect that investment. And it's not just money, it's time. It take years to develop these. So even with the fast growth of technology, it means you need to evaluate your inventions a little more closely to make sure it's worth looking at a patent protection or some other form of protection. But it's definitely important to still protect those investments that you've made.
You know, some might say that AI is already creating things. I know there have been examples of people who have said to their AI, write me an app to do X, and it does. That could be considered the intellectual property of the AI, or would the company or the person who asked the app to do it be able to have that intellectual property?
That's what they're trying to.
That's the question, isn't it?
That's the question. And again, this can vary. The intellectual property laws, although there's some commonality among different countries, it's not international, it's per country. So some countries, I think, I follow the news a little bit, but not US. Other countries are saying, well, if AI did it, then kind of whoever was in control of the AI, they're an inventor too, and you can also list the AI algorithm. Right now, the United States has said no, but it's hard to tell if and when that's going to change. So it makes a weird situation where if someone's inventing something and they use AI, and AI is the inventor, but you can't list them on the patent application, but the United States requires you to list all patents or all inventors, we're in a weird spot. So the new technology and new advances always create new issues for the legal industry and for the political and government groups that help manage it.
And I suppose that until the courts set precedents on such things, it's going to be an open question.
Mm-hmm. So I fortunately haven't faced that situation, but I thought about it. It's like, well, what if one of my inventors or clients that I work for, they come to me and it's like, well, really, it was this AI tool that came up with this, or it's definitely an inventor. It's like, okay, now what do we do? So I guess I'll wait and see what the current status is when that arises.
Cross that bridge when it presents itself.
Yeah, exactly.
So what are the unique challenges for the space commerce industry when it comes to patents?
It's a couple of them. Well, we're just talking about legal issues. As far as in space, not sure whose laws are going to apply. So you could have a United States patent, and that protects you within the boundaries of the United States. You can exclude people from making, using, or selling in the United States. If something's completely manufactured and used out in space, if you know that's how it's going to be run, then your patent's not going to be very valuable. So if you really want to evaluate your inventions and make sure a patent makes sense. And with space, the timeline to develop a lot of these things is very long compared to some other terrestrial industries. So I was talking to somebody recently about an invention that would be useful on Mars, but not until we have some kind of a colony, or at least some people living there permanently, or some kind of structures on the Mars surface. Like, well, that's probably 15, 20 years out at least. And he said, yeah, that would be optimistic. Well, if you get a US patent today, it expires in 20 years. It's in force, but then after 20 years, about the time when somebody would actually potentially be infringing it, it's expired. So it really comes down to looking at evaluating your inventions and see if they make fit. Sorry, I'm not talking well today. See if they make sense. Is it going to fit with your company goals? And is it an asset that you'll actually be able to use or benefit from? If nobody's practicing it during the life of the patent, it doesn't have any value.
And I suppose a lot of folks who might be listening or watching don't realize, because I didn't, that a patent expired in 20 years. I thought they were more like trademarks that can go on for 40, 50, 60, 70 years.
Trademarks can keep getting renewed as long as you're using it. So they don't necessarily expire. Copyrights do, but that's much longer term, 70 years. Patents, no, they expire 20 years from the date in the United States, from the date you file the application. And with a few rare exceptions, like pharmaceuticals that are going through FDA approval, you don't get to extend that deadline and you can't renew it.
So a space company that is developing something new, that they file the patent, but they still are in research and development, they don't get that same consideration as the pharmaceutical companies do?
Not that I've seen. The big exception, and I don't work in the pharmaceutical industry, but the biggest exception like that I've seen is for the extending it based on the FDA approvals, because that can be long.
Give me a little bit about your background, Steve. How did you get into this?
I've loved space and airplanes since I was a little kid. I grew up in Detroit, and one of the fun things we'd do on the weekend was we'd go to the airport and watch the airplanes land and take off. My dad was a private pilot, and he did work in the aerospace industry. We got to work on the SR-71 Blackbird years ago. So I remember, I'm going to date myself, it was probably kindergarten, first grade, that one of the Apollo launches, we were in school, we'd all gather around a tiny little black and white TV to watch the launch. And I launched model rockets. The first art paper I ever wrote for elementary school was about Skylab. So wow. I've just loved it. For the longest time, I wanted to be a pilot for my career. Then I got into computers and electronics in high school and just fell in love with that. So that's what I pursued, but still have always loved kind of thinking about just the invention side of things. And it really made sense then to get a legal degree and kind of combine those together. And that's what I do today. And it's what I love, the understanding the technical side of things, getting to see new inventions before most of the world, and then helping those companies kind of protect them so they continue to grow.
It only brings to mind the fact that in this era of homeland security, that kids can't go hang out at the airport anymore. I used to do that too. And you can't just go, if you're sitting out there at the airport fence with a camera watching the airplanes go, somebody's going to come have a conversation with you.
We used to just, there wasn't security, there's TSA back then. We could just walk in, and the Detroit Metropolitan Airport had this observation deck that was outside. So it was up on the roof of one of the buildings, so you could hear the aircraft. You're almost on the tarmac. And yeah, kids can't do that today.
With the increasing global competitiveness in space commerce, and there are some rogue actors, such as some of the more authoritarian governments, perhaps we'll say, that disregard international law. Does this negate or enhance the need for patent protection?
I don't really think it changes it very much. It certainly doesn't negate it, because patents are issued on a country by country basis. I see people talk about, we have a worldwide patent on something. There isn't a worldwide patent. If you want to cover all the countries of the world, or all the significant commercially for your industry, you're filing separate applications in each of those countries. Now, Europe, you can consolidate that into one. But if you get a U.S. patent application, it's enforced. I mean, a U.S. patent that's issued, it's enforced by the U.S. courts, by the U.S. government. It doesn't matter what the other countries are doing. I mean, they may copy what you're doing in their country, but that's really a decision as to whether it makes sense to file a patent application in those other countries. If they're not going to enforce your rights, then it may not be worth spending the money. But in the U.S., if another country comes in that's trying to sell something in the United States, or company in another country, then you can block it, because you can block people from making it within the United States, selling it within the United States, or using it. It's like customers in the United States. So yeah, there's always has been, and there always will be some difficult people out there. But from the patent standpoint, you look at the countries and the jurisdictions that are most favorable to you as a patent holder, and where countries where your potential market is. No reason to get a patent in a country where they're not likely to be making your product or selling it. So,
how common is the theft of intellectual property?
It's common. It's sometimes intentional, sometimes accidental. There's 12 million patents just in the United States, and not everyone is aware of all of them or the details. And even if you are, you may not understand what they cover. They're complex documents, and it's a little tricky to read them and understand what it really covers. But sorry, did that answer your question?
Yeah, it's it just, you think about you think about countries who will, or companies who will be based in another country that would set up a U.S. office, perhaps, and I'm sure that adds another level of complexity to the whole patent protection issue.
It does. We get situations where we may be filing a patent application in the United States, but they have development teams in other parts of the world, and they have inventors there. So sometimes it's not an issue. We can just name them on the U.S. patent application. Other times we have to get approval from the government where they live to file it in the United States first. So yeah, just a lot of issues there. But if you're dealing with, I guess, non-rogue countries, we all kind of work together. Because the same situation, somebody in India may have U.S. inventors, and they reciprocate. We reciprocate. So it's just kind of understanding the rules and navigating them. And if it's a country you're really interested in getting patent protection, chances are they're going to be relatively easy to deal with, and they're likely to have reciprocal agreements.
You've talked about this a little bit already, but give me an example of a kind of innovation that you think would not require a patent.
Let me give you two.
Okay.
One is, and I'm talking from the U.S. because I'm not an expert in laws of other countries. Software in the United States, if it's a pure algorithm, and the patent office likes to talk about, like, if it's something you can do in your head, it's not patentable. Now, that's not to say you can't patent software. It's just a matter of what it looks like and how you've kind of embodied it into a system. For example, some of the algorithms in the software that are running robotics systems or autonomous vehicles, that's patentable. Patents are issuing every week on software in those areas. So it's looking at the invention, and if you think it's a big uphill battle to try and get it issued, then in the United States, then maybe it's just not worth it. The other category is when you're evaluating it, what's the value to your company? I've sat down with companies that have some issued patents. It's like, so what? This is so specific. There's a dozen ways to design around it. Why did you get this patent? And I get some crazy answers, but one of them is, well, Bob, we thought he was going to leave, so we wanted to get his name on a patent application and hopefully keep him to stay, which in my opinion, it's a horrible idea, but that's really the big thing. Don't patent something just for the sake of getting a mediocre patent and having a number. I would get all your best inventions and prioritize them. And then whatever your budget is, file on the ones that really have value to your company and can provide either competitive advantage or give you licensing opportunities or something like that. If there's no value there, then I'd spend the money elsewhere.
I'm talking with intellectual property attorney Steve Sponseller on the Ex Terra Podcast. Take a moment right now to click subscribe to be sure you don't miss any of our podcasts, or if you're watching on YouTube, any of the videos from Ex Terra, the Journal of Space Commerce. Steve, you've written a book to help companies with the IP challenges called Cracking the Patent Code. Tell us about your book.
So I wrote that a couple of years ago when I had some extra time on my hands as the pandemic was getting started.
As many of us did.
And I was thinking back to some of my clients that I've worked with for over 20 years, and what was the biggest mistakes or what are the misunderstandings I see? And because I have leaders, CEOs and CTOs of significant tech companies. And when I initially started working with them, they didn't really understand. And they admitted it to me that I don't really understand this patent stuff. I see articles in the business journals and they all seem to conflict each other. So I thought, I've kind of got a 3-step system. So I can boil it down to identifying your inventions, evaluating them so that you can prioritize them, and then protect the right ones so that you start building a portfolio of patents it's a valuable business asset. So that's what I did. I wrote the book short and tried to make it something that's kind of easy to consume, but just to let people know, here's a system that works. Identified some of the critical deadlines that I see clients miss, and it prevents them from being able to file a patent on particular inventions. So it was just to get that information that I've been using out of my head and into some other people to help them and hopefully maybe keep a few people from missing some of these deadlines or realizing it doesn't have to be as difficult as they might seem.
So should companies and entrepreneurs then have an intellectual property or patent plan? And what's involved in creating such a plan?
Absolutely. I mean, that's what I do with clients. But the worst thing you can do is just not have a plan and just kind of randomly file a few patent applications on mediocre inventions. So when I put together a patent strategy for clients and work with their team, it's the 3-step system that I talk about in the book. Is put in place systems so you're identified all the inventions. Don't just leave it to people to kind of come to you. Be a little bit more proactive, whether it's through brainstorming or invention contests, things like that, to cultivate a big pool of inventions. Then evaluate them, set some criteria that's specific for your company so you can kind of rank, prioritize all the inventions that you discover. And then based on your budget and based on how valuable those top priorities are, file patent applications and start building a patent portfolio. That's my whole strategic plan, is to start building a portfolio of patents that can increase your valuation. We had one recently, a company I worked with from scratch, and their patent portfolio really helped with the IPO valuation. So we can't put a hard number on it, but those are the kind of things. And we started early. It was 5-6 years for that process, but there is a system. It doesn't have to be real complicated, but if you get the team members involved, then that strategy can produce some really good results.
Who is involved in evaluating a patent to see if if it should be issued?
I recommend, when I work with companies, I help them put together a group of typically 5 or 6 people, because you want different roles in the organization represented. Of course, you want somebody from the executive team You want somebody from marketing and sales, because those groups often get feedback from what the customers like, what the customers want. You definitely want engineering and tech people, because they can tell you how easy it is going to be to implement the invention. Because if you come up with an invention that it's like, no, this is going to take 10 years and $100 million without a good return, then you don't do it. And even the other one that a lot of people miss out on is your customer service team. Because the customer service team, they're often your front line to the problems. And if an invention comes along and they're like, we get people complaining about this problem that you're solving all day long. This invention's fantastic. This would help us so much. It would make our job easier. So getting that kind of cross section from the company, you get very different views because they have different roles and different perspectives. So that's the way I put together those teams.
What about on the other side of the process? Who in the government are the ones who are evaluating the patents to see if they're able to be issued?
Mm-hmm. So in the U.S. Patent and Trademark Office, they've got a team of examiners, thousands, and they examine the patent applications. They do a search, and then they examine your application and the language you've used to describe the invention against the other, we call it prior art, but the other documents they found that predate your invention. And they'll do their analysis and review it, and then send you back what they call an office action, which is their reasons for approving or rejecting the claims. And if they reject the claims, then they give some specific details that, the ABC reference teaches this part, and then this other reference teaches this, and somebody would have combined these together. So then you negotiate it, and you negotiate the application with the examiner. If you kind of get to a stalemate and you're not making any progress, and you can communicate written, or you can do video conferences like this. If you get to a stalemate, then you can appeal it to a review board, which will be 3 other senior patent examiners who will review it. You submit a brief, kind of like in court, and they'll make the decision and come back to you, and then you move from there. But that's the general process in the United States system.
How common is it, and what are some of the challenges for an invention that wants to improve on or significantly alter an existing product or technology?
I'm going to assume it means improving on someone else's technology.
Yes.
If it's your own, it's easy. If it's somebody else, it gets tricky, because you may. So if somebody invents a product and its key features are, let's call them A and B, and it's the A and B working together, that was an invention that was issued 10 years ago, a patent that was issued, and you come along and you add element C, and which is an improvement, which makes it even better. Now, the problem is you still may infringe their patent right, because you still do A and B, but you've got a better version. So it gets into potentially licensing. You can contact the original patent owner and say, hey, we've come up with an improvement. Would you want to kind of cross-license? If you don't sue us on your patent, we'll give you some kind of access to our patent on this improved technology so that you can practice it also. But most of the inventions, like I mentioned, there's 12 million patents in the United States. They're not all revolutionary, pioneering inventions. Most inventions are incremental. You take something that's done before and either apply new technology to it, or you found a new way to make it faster, smarter, or something. So it's very common to do that, to have an incremental improvement. And we do that with our own clients when they invent a new version of it. Consider, is that a big enough differentiator? We should file an additional patent application to cover that new improvement or that new iteration.
I'm going to shift gears a little bit. Tell me about your Tech Leader Talk podcast.
So my favorite thing to do with my clients is to sit down with a group of inventors or just team members, 6-8 people, and either brainstorm an issue they're working on or talk to them about an invention they came up with. Because I've got the engineering background to understand what they're doing, but I come in without the blinders on. They often get stuck in their own, we've always done it this way, or this is the architecture we have to work within. So they get an invention. It's really, really specific. But my job is to come in and say, let's broaden this out. I'm going to take a different view, or just helping them solve a problem. And I come in with a different perspective. I love that. Those are my best days because it just energizes me. So I got to thinking, how can I do more of those? And I love learning about tech companies, their innovation techniques and things like that, so that I could then share with my own clients. I thought, let me try the podcast. And it started as an experiment, and we're about to release episode 100. So it's going well. And I thank you. I have no problem, no plans to stop because I love it. And because I'm so interested in space, we're doing a space tech kind of series now where have interviewed, they're being released, 8 different space tech leaders on a variety of different topics, kind of a focus on innovation, but a lot of different things going on in the space industry today. And those have been some of the most fun interviews I've done. So it was an experiment that's become part of my life.
And then what about space tech innovation?
So that is a spinoff from the podcast. I decided I wanted to do a series of interviews with space tech leaders, and I reached out to a bunch of people. We've got a group of 8, but I wanted it to be more than just the podcast, because not everybody listens to podcasts.
Sure.
Sorry, believe it or not.
Trust me, I know.
So I wanted to we initially called it an enhanced product patent series, an enhanced podcast series. So what I've done is just created a website where we're putting together these interviews, and people can listen to the audio, they can watch the video. There's also an executive summary, and we edited a transcript, and we just put it together on a website. So it'd be easy for anybody to find it. And the links are on the site for each guest and a little bit of information about each guest. So just kind of a different way to kind of promote it, let people know it's out there. And then that website's going to hang around long past the publication of the 8 interviews, so that people will be able to find this information and go get it later. And we may be continuing it. I had so much fun with these 8 guests, and I've got some other people who would like to be on the show that are also equally interesting. So it may get continued into the summer.
So that's on a standalone website. I'm guessing your podcast is available wherever folks find their favorite podcasts.
It's on all the podcast platforms. Yes.
Steve, we're just about out of time, but we ask all of our guests to do this, and you're kind of like right in the middle of all the good innovation and seeing what's coming down the pike. So look out, if you might, over the next 10 to 15 years in space commerce, and tell us what you see.
What do I see? For me, I'm still involved in it. So I'm still there. I'm still going to be doing the same thing, still working with the companies. I guess what's most exciting to me is some of the brand new things. Now, I haven't been working in the space industry for a long time, but seeing some of the things. So I talked with a person the other day at Sierra Space that they're building inflatable structures in space, which kind of blows my mind. It's like, how do you have something inflatable up there that you're going to put humans in? And systems that are going to be autonomous. They're going to launch this package on a rocket. This is Think Orbital. And it's going to build the structure itself. It's got autonomous capabilities, a robotic arm. They're going to weld it together in space. And as I think about that, it's like the opportunities out there. I think there's going to be all kinds of new structures and new systems like that, where you can launch it within a size of a rocket payload, and then build it up there. And I think I was at a AIAA conference a couple of months ago, and they were talking about propulsion systems and a lot of the new technologies that are going to be able to move spacecraft in space. Some of them are nuclear, so they wouldn't be launching from Earth with that system. But if they can start cutting down, I know they will, cutting down the time travel to take humans to Mars. 7 months seems like a long time for me, but if they can cut that down to a couple of weeks and get to the moon and back even faster, I think that's a lot of what's going to be coming. And I guess my big vision is I'd love to be doing some brainstorming sessions in orbit or from the lunar surface. So we'll see if that comes to be.
Well, good luck. I may be a little long in the tooth to be doing a podcast from the moon, but maybe you'll get there.
Okay. I'll have you as a guest if that works out.
All right. If I can, I'll come sit in the studio with you on the moon. That'd be perfect.
Let's plan on it.
All about it.
Yeah.
Let's plan on that, Steve. It's been fun. Thanks very much. I appreciate your time.
Thank you, Tom. I appreciate you having me on the show.
Steve Sponseller is a patent attorney and the author of Cracking the Patent Code. And that's going to do it for this edition of the Ex Terra Podcast. You can subscribe to the audio version of the podcast on Spotify, Apple Podcasts, Google Podcasts, Audible, and many other popular podcasting platforms. Be sure to click on subscribe so you don't miss any of the podcasts or any of our other videos. You can also get daily space commerce news at xterrajsc.com. And one thing more, be sure to connect with us on LinkedIn and follow us on Twitter at xterrajsc. Until next time, I'm Tom Patton. Thanks for joining us.
I wanna go faster, faster. Hands in the air, we're gonna crash. Searching for the answers. My Galileo through his looking glass. Thirst for reason. Our dreamer's eyes we gaze into a sense of purpose, know my view. Like finding water on the moon.